Good morning. My name is Ian Ferguson. I was a director of Mitchells Robertson Limited. I am now retired and enjoying it greatly. And I'm also a council member of the Scottish Law Agents Society, and I still remain so. I'm here today to give a talk on Lands Tribunal for Scotland, an introduction. It will be done in two parts, and this first part will go through the generalities of what's involved here. First of all, the history. First of all, the Lands Tribunal Act of 1949 authorised the Lands Tribunal for Scotland, and the Act sets out details of its constitution and jurisdiction. The Act was to establish a new tribunal to determine in place of official arbitrators certain matters which have now been greatly expanded. The Lands Tribunal has statutory power to deal with various types of dispute involving land or property, and works in much the same way as an ordinary civil court. It was introduced because of the legal complexity of these areas, and it was composed of both legal experts and valuation experts. Two tribunals were constituted, the Lands Tribunal for Scotland and the Lands Tribunal for the rest of the UK. There was limited volume, and so the Lands Tribunal for Scotland was not set up at that time. There simply wasn't the business there for it at that point. Second came the Conveyancing and Feudal Reform Scotland Act 1970, of course one that we all really know very well. This required the establishment of a body to adjudicate upon applications to vary or discharge land obligations and allocate few duties, which is now abolished. It was decided that the power to set up a Scottish tribunal should be activated for this purpose. 3. There came the Title Conditions Scotland Act 2003, and this created new criteria for variation or discharge of title conditions. In the future, it's to be merged with the Scottish Land Court. So that's the history. If we go on to the constitution of this, the President is to be suitably qualified by holding of judicial office or by experience as an advocate or solicitor, plus 3 members at present who have recognised expertise in the fields of law and surveying. They are either to be persons suitably qualified or persons having experience in valuation of land, appointed after consultation with the chairman of the Scottish branch of RICS. The jurisdiction. There are 9 areas of jurisdiction, and I'll go through these briefly, concentrating on 1 or 2. First of all, discharge or variation of title conditions and of the development management scheme. So this tribunal has power to discharge and vary old feudal conditions and other title burdens, but also the development management scheme itself, which I suppose keeps it up to date. Secondly, the tenant's right to purchase homes under the Housing Scotland Act 1987. At present, that has all been abolished. Nothing like that is happening anymore, and it's not likely to return. Thirdly, disputed compensation for compulsory purchase of land or loss in value of land caused by public work under several acts. Now, the 2 main ones are the Land Compensation Scotland Act 1963 and the Land Compensation Scotland Act 1973. E.g., typical cases are following the compulsory purchase of land or depreciation caused by public works, for example, a new bypass. Another is claims for coal mining subsidence under the Coal Mining Subsidence Act 1957 and 1991. 4. Valuations for rating on non-domestic premises. 5. Appeals against the Keeper of the Registers of Scotland. This is power to hear appeals against decisions of the Keeper regarding the registration of title to land. Now, the position was amended by the Land Registration Scotland Act 2012. Section 82 provides that the tribunal is to determine questions referred to it regarding accuracy of the land register and what is needed to rectify an inaccuracy. Section 103 also gave jurisdiction to hear appeals in questions of fact or law against any decision of the keeper. That involves complex questions on property title, as well as cases involving simply disputes as to boundary. 6. Appeals about valuation of land on preemptive rights purchases. 7. Disputes under the Electronic Communications Code. 8. Voluntary or joint references in which the Tribunal acts as an arbiter. This is an interesting point. Here is a body that has quite a lot of experience of title conditions and the law generally. Under Section 1.5 of the 1949 Act, it can act as an arbiter under a reference of consent. In other words, if parties decide that they want something sorted, then they could do this. If both sides agree, any disputes regarding land can be referred to the Lands Tribunal, such as valuation of land. And that's an important thing to think about, that there is this option to use it as an arbiter rather than as a court as such or a tribunal as such. Tribunal members are experienced litigation lawyers and RICS surveyors, and dispute resolution infrastructure is available. 9. Review/arbitration powers under the Long Leases Scotland Act 2012, which converts a tenant's interest in land over 175 years into an ownership title where there is more than 100 years to run. So there's quite a lot of jurisdiction here, it's a bit of a hodgepodge of various powers they've got, but the main two that we're going to be concerned with, and I'm going to talk about today, are discharge or variation of title conditions and appeals against the Keeper of the Registers of Scotland. These are the two things that it's best for us to know about as conveyancers. Discharge or variation of title conditions. Pre 1st of March 1971, that's before the 1970 Act, discharge or variation was not generally possible without the benefited owner's agreement. A burdened owner could apply to the court for a decision that a condition was unenforceable, but it was difficult to succeed if it was a feudal condition. The superior could certainly show title to enforce and had presumed interest that he could enforce as well. The onus was on the burdened owner to show that he did not have such an interest any longer. Accordingly, the owner would be forced to negotiate with the superior to try to obtain a minute of waiver. And of course, trying to get a minute of waiver is probably the best thing to try to do when you're ever trying to get a title condition varied. If you can get this done by agreement, it's certainly going to be quicker and you're going to get the whole thing sorted, and it'll be a lot more certain in getting there. There's also extinction. If the burdened owner breaches a condition and the benefited owner does not take action on the breach, then the benefited owner was prevented from taking action. I'll give you an example. There is a title condition not to use a dwelling house as a shop or for any other commercial purposes. The house was used as a shop for 5 years without challenge. The superior cannot enforce that particular breach after 5 years under Section 6 of the Prescription and Limitations Scotland Act 1973. The title condition itself is imprescriptible. Remember that. The title condition is imprescriptible under the 73 Act, but the use as a shop for more than 5 years cannot now be challenged. If, however, the shop was then converted to a public house, then this would be a new breach of the original condition, and the breach relating to the use of the property as a shop has no relevance. Accordingly, the title condition could still be enforced and will not have been extinguished. Post 1st March 1971, under the 1970 Act, owners could appeal to the Lands Tribunal for Scotland to vary or discharge a land obligation provided that land obligation 1 had become unreasonable or inappropriate due to changes in the character of the land or neighbourhood or other circumstances. 2, it had become unduly burdensome compared with the benefit resulting or would result from its performance. And 3, impeded some reasonable use of the land. Now, this greatly improved the burdened owner's position. However, post-2003 Act, the position is even better for ordinary people with trying to discharge conditions, because here there is power to vary or discharge title conditions, there is power to determine any questions as to the validity, application and enforceability of a real burden, or as to how it is construed. Thirdly, there are corresponding powers under the rules of the Development Management Scheme. So again, powers now to amend the Development Management Scheme if it's got a bit out of date. We're going to look at section 90. Now, I'm hoping that you will be sent after this the copies of the sections, which I'm going to have to read to you just now, not having access to